Good afternoon, everybody. Welcome to CHK Law. Welcome to this month's Greater China Legal History Seminar. My name is Lutz Christian Wolf, and it's my great pleasure to introduce to you our speaker for today, Professor Chunlin Leonard, who will speak about contracts as tools to promote morality and social order, the Tang Dynasty's regulation on contractual relationships. Professor Leonard graduated from the Shanghai Foreign Language Institute, which is now the Shanghai International Studies University, before immigrating to the United States in the late 1980s. She received her Juris Doctor degree, magna cum laude, from Boston University. She began her legal career with the law firm of Latham & Watkins in 1996, after which, 3 years later, she joined the Chicago office of what later became part of the global law firm Dentons, where she was promoted to partner in 2006. Professor Leonard is Leon Sarpi Distinguished Professor of Law at the Loyola University New Orleans College of Law. In 2019, she won a Fulbright grant to research contract law during the Tang Dynasty. And her scholarship focuses on contract law issues in the cross-cultural context, as well as the impact of behavioral economics research on common law contract law. Her articles, as many of you will know, appear in many different law journals she has widely published. Now, before I pass the floor to Professor Leonard, let me say that Professor Leonard has kindly agreed to be available for a Q&A session at the end of this seminar today. If you have any questions, please use the chat function, chat them in so that I can read them out to Professor Leonard. Professor Leonard joins us today from the US. I think it's midnight. So we are most grateful for you to be so flexible for the benefit of the Asian audiences, of course. And it's really nice to have you with us, Professor Leonard. Thank you for joining. Thank you for delivering the seminar. With this, I'm passing the virtual floor to you, please.
Well, good afternoon, everybody. Thank you so much, Dean Wolf and Professor Gallagher, for inviting me to be here. And of course, thank you all for taking your lunchtime to be with us today. Now, I just need to figure out how to share my screen. But while we're figuring this out, I'd like to actually, first of all, thank a lot of the Chinese historians and legal historians, as well as archaeologists, for really devoting the time and the effort to preserving these documents that was excavated from the tombs in the Tuofen and Dunhuang area. Without their painstaking effort to preserve these documents and to interpret them, to make them accessible to people like me, my work would not have been possible. So I'm really grateful for their contributions. And I also would like to give a shout out to Professor Valerie Hansen, who is a history professor at Yale University. And it is really her work in this area that inspired me to actually to start examining the contracts from a legal perspective. So I'm really grateful to her work, extensive research in this area as well. All right, so let me see how I can share my screen. Sorry, hang on. Here we go. Here we go, all right. All right, I hope you can see my screen now. Excellent, thank you. I see the thumbs up. Thanks, Professor Gallagher. All right, so basically, my topic today is really focusing on contract law, but during the Tang Dynasty. But I'm always a strong believer in, if you want to understand the law, you do need to know the context which gave rise to them. So that's why my presentation today is going to focus on four different areas, but related. So I wanted to start with an overview of the Tang Dynasty, which is often called the China's Golden Age. And this is really just, it's going to be a real brief overview, really to provide the cultural context for us to understand the Tang laws better. And then we're going to, I'm going to give you also a very quick introduction about Tang laws and sources of law, as well as the judicial system, which is was created to or maintained to enforce the laws. And then we're going to come to the heart of the discussion today, which is the Tang's regulation of contractual relationships. And lastly, I'm going to actually, try to explain how the Tang regulations of contractual relationships are actually reflected in the contractual practices at that time. So these are the 4 broad areas. And when I'm done, I welcome any questions you may have on this topic. All right, so with regard to the overview on the Tang Dynasty, I'm going to quickly cover about what are the core in the Confucian beliefs that actually impacted the Tang society as a whole. And then we'll talk about the strict, really hierarchical class system that was maintained at that time, because that all has to do with how the Tang laws were crafted and give us a better understanding. And then I will talk quickly about the administrative structures maintained at that time, which were essentially designed to help the emperor to manage the country. And then we'll also touch upon quickly about the land ownership. And that is a pretty complicated area. And I really don't intend to go into any in-depth discussion, rather enough to give us an understanding as to how the Tang laws regulate the purchase and sale of land during that time. And then we'll talk about, of course, commercial activities, right? Because when we think about contracts, that's really what contracts are used for, commercial activities, essentially, right? We'll talk about in the United States, we talk about contracts essentially is the private ordering of economic relationship between the parties. So, all right. So on the first topic about Confucius, we know, as you probably all of you know, that Confucian ideology became the state ideology during the Han Dynasty. So, and essentially has remained so throughout the Chinese dynasties. And so when the Tang emperors came into power, they embraced the Confucian ideology wholeheartedly. In fact, Tang Gaozu devoted a lot of resources to printing books and on the teachings of Confucianism. And as you know, a lot of the official exams essentially featured Confucian beliefs. So in order to pass the exams, the examinees had to memorize a lot of the teachings. So you see, Confucianism really impacted the society as a whole. The core Confucian beliefs, I'm sure you're all familiar with, essentially the Confucian beliefs are centered around some key relationships and basically focused on filial piety, loyalty, chastity, and benevolence. So central to this relationship is really the concept of Li, which is a very broad concept, kind of defines definition, but some Chinese scholars have basically described the concept of Li as sort of the soul of the Chinese culture. So essentially, Confucius was trying to encourage people to behave towards each other by following Li, and he was urging people, especially relevant to contractual relationship, is that the trustworthiness, to be trustworthy towards each other, and using trustworthiness and loyalty as a guide to people's relationships. So that's basically his some of his core beliefs. And this entire Tang society was divided into 2 broad classes in a strictly hierarchical order, with the emperor sitting right at the top, as you can see from this pyramid that I kind of pulled off the internet. All right, so essentially, so the 2 broad classes, one is the officials. If you imagine the massive bureaucracy that was in place to help the emperor govern the country. So there are a lot of officials, right? So they're called guan in Chinese. And these people, of course, are strictly ranked as well, from 1 to 9, with 1 being the highest. But this is a system that has been in place throughout the prior dynasties. So Tang Dynasty did not invent this, but this just continued from the prior dynasties. But the Tang laws really essentially regulated this very strictly, including color-coded clothing for each level. So so it is highly regulated. You imagine, when I was reviewing the laws, it's incredible details as to exactly what you could wear and what the hat was supposed to look like and stuff like that. So well, the second broad class was commoners. That's just the people that's being regulated. And among the commoners, there's one class of people they call the Liangming. This actually, I translate into free class, and some people have translated into the good people, which I think is not really the correct translation, because, and just so you know, a lot of the Chinese, the English translations, I basically used my own translation as opposed to relying on existing translations, using my own judgment. So you see the discrepancy, some of the discrepancy here. So the free class, these are the people who basically, they're all further divided into scholars, farmers, workers, and merchants. And these classes of people are also very strictly regulated. In fact, town statutes and rules basically prohibited them from interacting with basically, like, scholars cannot do any work that's related to merchants. It's considered below the status. So scholars is held to be a higher status than merchants. So and then the second class was what they call Jianmin, and I translated that into inferior class. And these are the people who consist of low-level guards and government indentured workers, or miscellaneously indentured servants and slaves, of course. And the slaves being the lowest of the lower class, essentially, because they were treated as like livestock, which can be sold. And you're going to see that it's unimaginable for us now, but at that time, they were being sold as livestock. And that's reflected in the contracts that I examined. So with regard to the administrative structures, this is so the Tang emperors relied on a central administrative system to essentially help them manage the entire country. And typically, so people have talked about the 3 ministries. So Shenshen. Now, here the translation in English has been translated variously as the province, which I do not like, because I think the word province confuses the modern usage of the word province, which is basically a geographic designation as opposed to administrative. So and then some people also translate as department, but I chose the word ministries because I think that denotes the right level, because it's at the top level, the central level. So the first one is the Ministry of Secretariat. So note here, I'm not using the literal translation because the literal translation would make no sense to people. So that I translated them based on the function of the particular ministry. So in this case, the Secretariat was really responsible for the drafting of laws and orders on behalf of the emperor. And then the Ministry of the Oversight of Review, they are basically responsible for reviewing the decisions from the Secretariat and government administration. And the government administration is the one that's responsible for executing the laws and managing the country's affairs. So, and within the government administration, they had 6 separate departments. And you can see that these are really, you can see how the government administration managed the country through the 6 departments, which has to do with personnel, households, rights, military punishments, and works. So, And then within the 6 departments, they also have agencies underneath it. So you can see the structure in place, which essentially allows the emperor to have a pretty tight control over the entire country, but through a lot of officials or bureaucrats. Some people call them bureaucrats as well. So anyway, so there's at the central level, there's also 9 agencies and 5 supervisory departments. So the entire point of this slide is to show you just the sheer number of people or government officials involved in order to manage the country for the emperor, essentially. So geographically, the country, and this is the map I pulled from the Cambridge History of China site. And the entire country is organized as prefectures and counties. And there's, for example, there's a total of 228 prefectures and 1,573 counties during the 28th year of the Kaiyuan reign of the Tang Dynasty. So, and then the counties, of course, are further divided into smaller administrative units, like towns, blocks, sections, and neighborhoods. In fact, I visited Taiwan in early January of 2020. I made it there right before the COVID and came back before the lockdown happened. I noticed when I was walking around the streets that the Taiwan still followed the system. They have blocks, sections, and neighborhoods. It was very interesting. So the smallest unit geographically is really the family, which is the head of the household, and generally is the father, the male head of household. All right, so here I want to talk very quickly about the land ownership. So of course, land during that time, like all the emperors prior to the Tang Dynasty, it belonged to the state, and the emperor, and the state collected taxes based on land ownership. So Tang Dynasty continued the equal land allocation system, which basically was a system adopted about 485 CE in the Northern Wei Dynasty. But Tang Dynasty, so it went, so the Sui Dynasty, which is the one that's immediately preceding the Tang Dynasty, also adopted the equal land allocation system. Essentially, the system allows essentially allocated land to farmers based on very specific rules, and farmers in return would pay taxes and also fulfill other obligations to the state, such as free labor and military services. One of the fascinating area of contracts that I saw when I was reviewing the contract was how many of those contracts were to hire people to conduct military services for them. So I guess it must be at that time, if the person had more money than time, they would hire somebody else to perform the military services. So I thought that was interesting. But so for example, just to give you an idea, so one allocation scheme is each male at least 18 years old up to middle-aged, they get 100 mu of land, 20 mu of which was going to be it's going to be treated by law as the permanent land, which is inheritable, meaning it can pass through to the next generation. But the rest, 80 mu, had to be returned to the state upon death. And this is going to be relevant in later when we talk about the restrictions on sale of land by the town regulations with regard to sale of land. The land ownership is also complicated. Like monks, nuns, and government officials also get allocations. In fact, government officials, as a matter of when they did something that the emperors wanted to award them, they would also award them land, basically that in addition to the allocations. So that's why. So in a family of a certain size, you can have a land that's classified as permanent land or household land or award land, or sometimes some of the officials would get a piece of land because of their official position. So they can, so those are all the different forms of land ownership. So you can imagine how much effort it would require to keep track of that. And especially when the laws essentially place limitations on the purchase and sale of only certain types of land. All right, so right, we're not, so with regard to land ownership, it's really a fascinating area of law, and I really didn't have the time to get into further details before the lockdown occurred and I was evacuated out of China into the United States. So that was in early February of 2020. But anyway, that's a side story. All right, so now coming back to the commercial activities, and that is really very much relevant to contractual relationship. A lot of scholars have pointed out that Tang Dynasty really had a lot of vibrant, really, trading activities, both domestically and internationally. And the activities were happening both in designated marketplaces or as wandering sales merchants, essentially. So, and domestic industrial activities span from textile to weapon manufacturing, transportation tools. So in fact, one scholar pointed out that Chang'an City, which is the modern day Xi'an, had over 200 different types of trades alone. In addition to private industrial commercial activities, the Tang rulers themselves, the emperors themselves, also have their own industrial activities, both at the central and the local level. The industries that's controlled by the Tang rulers were really responsible to manufacture items for daily life, products for military use, construction and building materials, and manufacturing activities specifically to meet the needs of the emperors and their courts, basically. So yeah, it reminds me of the dual track economy that we see in China right now with private economic activities and the centrally government-owned, state-owned enterprises. So we can trace that back to the Tang Dynasty or even earlier for that matter. All right. So with regard to the commercial activities, Tang laws specified the detailed rules about where markets could be located and when they could open. So basically, one statute basically provided that markets could only be located in prefectures or county capital cities. In fact, if a prefecture had over 10,000 families, there has to be a market supervisor office. So the market supervisor actually plays a big role in the commercial activities. They were responsible for supervising the markets and preventing any illegal activities, for certifying certain sales transactions. So some contracts require certification by the market supervisors, and they were supposed to value goods at specific time intervals. Like they can value the goods as good, average, and bad, basically. That's the and they're also, one of their important functions is to make sure that the measuring instruments in the marketplace were accurate. So there are private measuring instruments which the market supervisor was supposed to check, and there's also government measuring instruments that essentially the market supervisor has to make sure that they were accurate. All right. Now the trading activities were also happening overseas. The land trade route is very familiar, I'm sure, to you all, which is known as the Silk Road. The beginning of the Silk Road was at Chang'an City at that time. But there's also a maritime route through which the Tang Chinese were able to trade with foreign countries. In fact, the maritime route, in 1998, some fishers basically discovered a sunken ship in the Belitung Island area in the Java Sea. And so this map that I pulled off Wikipedia, essentially, I just wanted to show you the location of this sunken ship. So it was an Arabian dhow. And what was amazing about this ship was that it was carrying about 70,000 ceramics that was manufactured in the Tang Dynasty through different regions of the country at that time. So that was the earliest ship found in Southeast East Asia so far. And scholars have basically described that as proof positive of the active maritime trade in the 9th century among China, Southeast Asia, and West Asia. So if you see the red line was the expected route of this ship, but so it takes us along the coastline to different countries. Now, I actually happened to be in Singapore this past summer, and I saw at the, I visited the exhibit at the Asian Civilizations Museum in Singapore of the sunken ship, where all the ceramics, a lot of the ceramics were displayed. They were in as you can tell from the photos, they were in remarkably good condition. And it was really basically pieces of artwork in my mind. And so I thought I'd share some photos with you, so you have a feel as to what kind of ceramics were being manufactured in Tang Dynasty at the time. So it was really a worthwhile visit. All right. So so that was just a very quick overview to give you the proper context for us to discuss about really Tang regulations of contractual relationship. But we need another set of information, which is the Tang laws and sources of laws and the judicial system. So I'm going to go over that very quickly as well, so that you have a rough idea as to what the different the laws that's in place and how the laws were drafted. So I'm going to talk briefly about the Tang laws and the Tang Code itself and its evolution. And also the second area was the judicial system. Those are the agencies that's responsible for the enforcement of laws. So very superficial review of those areas. So I found this remnants of a handwritten page from the Tang Code on display at the Xinjiang Museum. Now this was one of the museums that I had planned to visit, but I couldn't do it because of the lockdown. So essentially, it was really regrettable, but I'm not complaining because I'm very grateful for the opportunity that I had. But anyway, so about Tang laws and the Tang Code. So following the previous dynastic tradition, Tang laws also basically follow this regime of code laws, which basically is considered the formal law, essentially set forth primarily basically criminal punishments, and statutes, which are more aimed at organizations and really intended to supplement the code laws, and decrees. And those are basically a collection of the emperor's orders that's formalized into decrees. So emperors would periodically issue orders, but then the responsible agency would kind of collect them and basically put them into a formal decree. And then that's basically called the decrees. They're basically emperor's orders. And then agency rules are really basically view them like administrative rules that's for the functioning of the different agencies. And the emperor's temporary orders, that's before they were organized into a collection of decrees, they're called chi. It also has the force of law, but it's only to address a very specific narrow area. And before they are collected as in a formal volume, they're called chi as opposed to decrees. All right. So about the Tang Code. Well, so basically, when the Tang emperors, Li Yuan, he was the Tang Gaozu, he was the first emperor in the Tang Dynasty. When he came to power, one of the first thing he did was to engage in legal reforms, because scholars have pointed out that his incentive for doing that is because of the lessons that he learned from the Sui dynasty. So as you know, Sui dynasty only lasted about 3 decades, not very short-lived. And the part of the Tang emperor's belief was that the reason why Sui dynasty did not last that long was because of the cruelty of the laws, and basically which resulted in the lack of law and order. So Tang Gaozu was very intent on reforming the laws as soon as he came into power. So the first one was known as the Wude Code, and that's he had the Sui Code essentially revised, and that became known as the Wude Code. Wude Code then basically was then further revised when Tang Taizong came into power. That's Li Shiming. So he basically went to also and undertook extensive revisions of the Wude Code, and that became known as the Zhenguan Code. Now, so when Tang Gaozong came into power, he again renovated the Zhenguan Code, and that became the Yonhui Code. And what else he did was Tang Gaozong, he actually had it annotated. So the annotation was supposed to really instruct people how to apply the law. And that was, so it looks like the scholars agree that the annotated Yonhui Code was the original so what's later known as the Tang Code was essentially originated from the annotated Yonhui Code. But there's a disagreement as to exactly which version of the Yonhui Code was the complete surviving code. Some scholars believe that it was the one that was actually annotated in the Yonhui area, but some other scholars believe that it might be the later version that was that survived that survived until today. But so in any event, the name and Tang Code, Tang Li Shui, was not given the name as the code, the Yonhui Code known as at the time. So this name, the scholars suggested, probably could be given later in time, like more like in Yuan Dynasty. So so when I call it the Tang Code, it's really the later name that scholars given to the annotated Yonhui Code. Now, the Tang Code itself had about 500 articles. There's some discrepancies with among the different versions, but it's about 500 articles. Now, at the time, the articles were not numbered, but over the years, scholars numbered the articles so that for ease of reference, and that have been multiple, scholars have devoted their lifetime to basically interpret the code and make them more accessible to modern Chinese readers. So, the Tang Code itself, when you look at it, consists of 12 volumes, which, if you think about it, is pretty, from a legislative drafting perspective, it's pretty amazing, because it divided up the code, the articles into different subject matters. For example, Article 1 actually has to do basically it called Mingli Lü, but it contains the general governing principles and the names of the crimes. So, which reminds me a little bit of for those of you who know about the Uniform Commercial Code in the United States. The Article 1 was also sets forth the general principles and the definitions. So from a legislative drafting perspective, it's really a pretty remarkable piece of legislation. And it focused on, clearly, when you look at the titles of the different volumes, you realize that they were focusing on the stuff, on the areas that's important. For example, one area has to do with the imperial guards. So where you can tell that because they needed so many people, guards, for the different emperors and the palaces, they need a body of law governing their behavior. And then they also have a volume devoted to government offices. So that, again, it has to do with the massive administrative structure with all the government officials. So you can tell regulating their behavior is an important task. And another section has to do with household marriages, and clearly, maintaining the family was important, was one of the important values of Confucian ideology. And then there's also an article governing stables and warehouses, right? So this, you can imagine stables and warehouses were pretty much the mode of transportation at that time, and they need laws governing that. And also govern unauthorized activities, theft and robbery. So those are the different titles, and also, of course, a section on assaults and disputes, and a section on miscellaneous issues. So that's where you collected a lot of different stuff that don't readily belong to a subject matter. And they also have a section on arrests and escapes, and on judgments and imprisonments. So all those divided up by subject matter areas. So it's really a pretty remarkable piece of legislation. So for purposes of my research, I basically review the entire town code, trying to identify what the articles that I view would be regulating contractual relationships. And so that's basically what I'm going to be focusing on next, after we finish talking about the judicial systems. So, all right, with regard to the town judicial system, so basically there are three, what they call the adjudicative agencies at the central level. One is the Office of Justice, so 大理寺, and this office has jurisdiction over crimes committed by all central government officials, as well as cases within the capital city, which at that time is Chang'an, involving crimes calling for punishment with imprisonment or above, and jurisdiction to review death sentences rendered by the regional offices subordinate to the Department of Punishments. And so the Department of Punishments is Xinbu, essentially is charged with reviewing decisions by the Office of Justice involving banishment or imprisonment, and decisions involving imprisonment or above from county or prefecture levels. And death sentences had to be reported to the emperor directly for review as well. And then the Bureau of Judicial Supervision, which is intended as the supervisory agency of the other two, the Office of Justice and Department of Punishments. And it could also participate in the adjudication of important cases and handle administrative lawsuits. So in a way, you can see here that scholars have commented on the structure of these offices, and essentially it creates its own checks and balances. So there was discussions about the emperor not trusting anybody, having any department having too much power in one agency or one official, but the emperor wanted to retain to be the most powerful person. So that's why the authorities kind of divided up, and they act as checks and balance on each other. So that's how it's set up. And so at the so that's the central level. So at the local level, so this is also reflected in the prefecture and the county levels, right? In fact, based on what I could find, there seems to be officials that's so at the county magistrate level, these are the people at the county level officials, and they're basically supposed to resolve all the disputes, but they do have specific officials dedicated to help them resolving disputes. So so that's how it's so at the central level and at the local level. And typically magistrates, for example, would have jurisdiction over crimes that only requires punishment by lashes, basically, or below. So they're supposed to deal with minor crimes. And then if it gets any serious, it has to be pushed up to the prefecture level. And so that's, so you can tell, oftentimes the towns and counties and the sections, they all have their, a lot of the neighborhood disputes are resolved at that level. So really didn't really get into the county magistrate's office. So one of the things that is really unfortunate that I haven't been able to was to really looking at how the magistrates and the officials are resolving disputes, since I haven't seen any court opinions, written opinions from that era. So that's a huge blank in my mind as to with regard to how disputes are handled during the Tang Dynasty. All right, so now I'm moving on to section 3, which is really the heart of my presentation today, talking about regulation of contractual relationships. And I have to give a couple of disclaimers here or caveat here. So one thing, well, for lack of a better vocabulary, right? So I basically use the US contract law vocabulary to try to describe what I see from among the town laws, which I gleaned from the town code. So simply because I don't have a better vocabulary and I don't know how to characterize them otherwise. And since I'm a trained US lawyer, I just resort to US vocabulary, contract vocabulary. So that's one thing. And the other thing is, I know, as I was very consciously aware as I was reviewing the documents, that I'm looking back in time at a basically over 300 year period, right? So, but because of lack of consistent records, I was not able to trace changes of laws over time. So when I'm talking about contractual regulations, I may give you the misimpression that this is nothing has changed, it's synchronic, but it's actually, if I can see evidence of changes over time. So I'm basically giving you a glimpse of what's going on at that time. And it's by no means a complete picture or a coherent picture. And I'm not able to trace the geographic differences here because most documents were preserved by accident, basically in the northwestern area, which currently Xinjiang in that area because of the dry climate. And also because a lot of there was a tradition at that time about using paper as barrier cloth. So it looks like a lot of people were recycling the paper from the government offices to make barrier cloth. And that's how they were preserved, really by accident. So as a result, though, the contracts that I review all from that area. So in other words, I didn't have any record and didn't really, given if I had more time, I would have tried to look into what's happening to the rest of the town, areas in the Tang Dynasty during that time. So I just want you to keep that in mind, right? All right. So first, I'm going to talk about the Tang regulations with regard to capacity to contract, right? So basically, under US law, which is basically whether or not the person is competent to contract. And then I'll talk about the restrictions on certain types of sales transaction during the Tang Dynasty based on my review of the Tang Code and also the statutes sometimes. And one thing, and they talk about how Tang laws recognized mutual agreement by the parties. And also we go into a little bit more detail about the regulations of the terms of certain contracts and certain contract formalities for sales of slaves and livestock. And then we'll also focus a little bit about the real estate transactions, essentially how Tang law regulates contracts involving sale of land. And then we'll talk about contract breach and liabilities and who is going to be held liable when people fail to perform under the contract. And then finally, I'm going to wrap up the discussion here by looking at regulation of government official contracts with commoners. Now, this is something that's unique to the dynasty, right? Because of the massive amount, the massive administrative structure and the number of government officials involved in running the country. So I find it to be very telling that we have a specific set of laws regulating government officials' contracts with commoners, which really shows the foresight in the legislative drafting in this area, right? But anyway, so all right, so back to capacity to contract. Well, here you can see this is where the Confucian ideology gets reflected in the Tang laws. Essentially, only heads of household could enter into contract for sale of slaves, houses, land, livestock, or other properties, or use them as collateral for a loan. So when I look at this, I kind of think, okay, so those are contracts that's important to the people at the time, right? Slaves, houses, land, livestock, or other properties or use them collateral for the loan. So in fact, if parents are alive, nobody, if they are living like within 300 li and within the border, the children cannot enter into a contract. So doesn't have the capacity to do so. So, and interesting enough, they also town code also prohibited specifically princess and concubines from entering into sales contract on their own, or directing their relatives, employees, or servants to do so. So I guess if you think about it, the court, right, the emperor's court, he had a lot of children, a lot of wives, and certainly they were not allowed to enter into contract. So they basically lacked the capacity to contract here. So now a lot of the sales transactions were prohibited, and if you look at the list, you understand really makes sense, right? So private possession of weapons, you can't sell weapons, armor, mechanical bows, different types of long spears, and of course armors, understandably, right? Because those are the weapons, you don't want people to possess weapons. And also certain official emblems like stamps, seals, and that they used basically to issue orders from the court as a symbol of the court, or insignia from the court, those are not prohibited from being in a private transaction. And also, you can't sell free people. Those are the people in the free class against their will. That was illegal. In fact, there's a presumption here. It's also of children at 10 years old are presumed to be involuntary because they were deemed to be too young to make their own decisions. In fact, under US law, you also, children under age doesn't have the capacity to contract. And if they do enter into contract, it's voidable by them. So, so in the way, so it reflects the recognition at the time that children under 10 years don't really have the capacity to agree, essentially. And also, you can't use free people as slaves, essentially as collateral for loans. One of the things that's really interesting about the contracts that I looked at was the number of contracts that has to do with loan transactions. So there's a lot of money borrowing going on during the Tang Dynasty, which makes a lot of sense, right? Because if you think about the commercial activities and agricultural activities, you all need money. So, sometimes, which is not always, private sales of daily necessities such as salt, liquor, and tea. So couldn't really tell why, but I suspect sometimes it's because the government, the state wanted to monopolize the sale of salt, for example. It can be a precious commodity, liquor and tea at certain times. And some foreign sales of copper, zinc, lead. Those are the materials that used to make coins. So that's also prohibited sometimes. So couldn't trace the at what period of time, but essentially they at certain points in time they were prohibited. Then the sometimes there's also prohibition of foreign trade, essentially. So we're talking about protectionism here. Sale of various silk products, yak tails, pearls, gold, and iron, I guess. So depending on, I guess, the times, and certain products can be so precious that the emperor just didn't want any of those to be sold to foreign countries. So those are the typical restrictions that I see that I saw. Now, one of the things I noticed that was pretty interesting about the Tang Code is that there's an explicit recognition of private collateralized loan agreements based on mutual agreement. Essentially, Tang Code specifically says that if it's private collateralized loan agreement, we're going to defer to the agreement. That's now with regard to sales transactions. Here, the choice of words is interesting. It's basically they prohibit coercion in purchase and sales transactions. So some scholars interpreted this as being saying that they wanted to also basically respect people's will to contract. I'm more looking at this from the perspective, basically they want to maintain market order. They don't want people to basically create chaos in the marketplace by coercing people to engage in purchase or sales transaction. But in any event, so and then as the town law and sometimes the statutes, which supplements the town law, also create some contract formalities essentially. So it basically provides the contracts involving sales of slave livestock such as horses, cattle, camels, mules, donkeys. Those are livestock, so important to people's lives. Had to be in writing and certified by market supervisors. So here you see under a U.S. contract law, statute of frauds, same thing, right? Contracts that are important, contract for sale of goods over $500 or more, contract involving marriage, contract involving land, all required to be in writing. So you see similarities here. And if it's a sale of slaves, so here there's actually special safeguards if it's a sale of a slave. So two basic government agencies had to certify sales of the slaves. In addition, the county magistrate had to physically inspect and question the slaves, especially to make sure that they were indeed slaves, and because free people were not supposed to be sold. And then town laws also regulate certain terms of the contract. In fact, there are quality requirements. For example, silk products, they have to be manufactured specific measurements. I think one of the things that's important is because silk products were actually one of the official currencies, in addition to coins, copper coins, and silver coins. Silk products could also be a currency, was one of the official currencies at the time. So products manufactured for the government has to be manufactured to specific quality. And in fact, sale of slaves, livestock, there is a what I feel like it's similar to an implied warranty of quality here. Essentially, if they refuse to eat or drink water within 3 days, the buyer didn't have the obligation to buy, essentially. So there's sort of a statutorily imposed warranty of quality here. And with regard to collateralized loan agreements, the amount of regulation really suggests how extensive the loan transactions were. Essentially, there's restrictions on maximum interest rates and loan transactions, although it's not clear how much that's enforced, because I saw plenty of contracts where they were charging more interest rate than was allowed. But couldn't tell if those were actually enforced. There was basically regulation that accumulated interest could not exceed 100% of the principal amount, regardless of the length of the loan. And then so there was apparently, people were borrowing grains and using grains to pay as interest, in which case the loan term cannot exceed 1 year. And the compounding of loan interest is also prohibited. And also the creditor could not sell the pledged property to third parties without the debtor's consent. And periodically the emperor would issue an order, basically a broad amnesty for private or public or private debts. In fact, there's one order that I saw basically where the emperor was saying about how people were exploiting the poor people, and how poor people were being so desperate, being chased by these debt creditors, and that's why he just issued the order, essentially wiping out certain types of private or public debts. So now real property transactions, essentially, there is a lot of restrictions here. So but mostly it's the basic restriction is that household land cannot be sold. In fact, but if you are an official above 5th grade, you're allowed to sell household land as well as the awarded land that was awarded as a result of his office. And the other, household land could be sold under certain conditions. Like if you're supposed to move to a different areas, you're allowed to sell. And if you need burial expenses, so there are situations like that. And there's also procedural requirements for sales of real property. In fact, there's a requirement that if you want to sell land, you have to first ask your family members And then if they say no, you have to ask your neighbors. So there seems to be an implied, right of first refusal with regard to families and neighbors with regard to piece of real property. So, so that's very interesting. This is like a statutorily imposed right of first refusal. So you can see here that this is the town code's attempt to protect the family structure and essentially forcing people to keep the land in the family if you want to sell it, essentially giving the family members the right of first refusal. All right. So contract breach and liability. So essentially, so here, the perception in the West that there was no contract law in dynastic China, commercial law in dynastic China, is really because a lot of these provisions, are embedded in the town code, which is a criminal statute, right? Known as the criminal statute. So as a result, a lot of the liability is criminal liability, ranges from lashes to with a small stick or lashes with a big stick. Essentially, that's the variation. Oftentimes, thankfully, there's a limit as to the maximum number of sticks that you can assess if somebody breached the contract, and the severity of the penalty depends on the delay, the amount involved. And also if the creditors try to seize the debtor's property without informing the government official, and if the value of the property seized exceeded the amount owed by the debtor, it's also criminal punishment. And guarantors and other intermediaries are also criminally liable. One of the remarkable thing about the town contract is there are multiple guarantors often in the contract. So the creditor's right to collect debts was also restricted. And this seems to be like, so if the debtor had already paid interest in an amount that's double the principal loan, the county magistrate was basically told, don't accept the petition, essentially. So there's also sort of like a statute of repose with regard to debt that's 30 years or older. Essentially, even if the loan agreement is in writing, there's no more cause of action for collecting the debt. And really interesting is a third-party right of action in case of a loan agreement that's charging illegal interest rates, right? So this is more like the Tang Dynasty version of Cheatham action in the United States, which basically allows the third party to basically sue the on behalf of the state. The private parties are charging illegal interest rate. In fact, as an incentive, basic town law would allow the third party to get the interest that was illegal interest that was paid as an incentive to bring this type of action. So very interesting provision there. All right, so and also, okay, so now let's talk quickly about the government officials' contract with commoners. For me, it's when I read that, it's pretty clear they recognize that the government officials are in a position where they can give them an unfair advantage. So they basically actually says that these regulations are applicable to their transactions with the commoners even before they officially assume their offices, applicable upon appointment, essentially. They are not allowed to borrow money from people under their supervision. And if they engage in a sales transaction and make money with it, they're going to treat it as if they committed a crime by accepting what they call dirty money, basically bribes, essentially. And the restrictions actually extend both to the officials while they are in office and in their retirement, as well as their families. But the degree of punishment reduces depending on whether they have knowledge or not. So detailed regulations on that. And so now I wanted to just talk quickly about how the Tang Chinese used contracts, right? So one of the things I discovered is that they typically follow a very specific format, and the parties themselves really view contracts as private laws between the parties. The contracts also, you can tell because of the way it's drafted, they were trying to comply with the legal requirements because sometimes they would mimic the town code, essentially. And they also, the Tang Chinese were using contracts to basically take advantage of the legal protections. And they were using contracts just like the modern day people, essentially to minimize or allocate transactional risks. So in the United States, we always view contract as a tool, as a risk allocation tool. So that's exactly what the Tang Chinese were doing. And they were using contracts really to deter non-performance. So typically the contract, you're going to see it's going to start with the date, names of the parties, subject matter, and the short description of the transaction, and a few standard phrases, typically dealing with product quality or other issues depending on the transaction. And so one of the reasons, the explanation as to why it is so short is because paper was expensive at that time, and there was a high illiteracy rate. And there's only certain people who are educated as scriveners to basically write down the contracts. So when I reviewed the contract, I counted, there's one scrivener, Wang Shiyu, he himself, just among the preserved contracts, he wrote 3 and another one wrote 4. So you can tell that the same people were writing these contracts and they were probably trained the same way, hence they follow the same format. So I wanted to show you an example. This is what I got of the picture. You can see the shape of like the clothing, right? And that's how the Chinese archaeologists basically preserve this. And then the transcription is below here is the transcription. And this is pretty much the length of a lot of the contracts, really very short. All right. So the contracts, how is that reflected when we say how did the Tang Chinese view the contracts? In a lot of the contracts, you will see this phrase or similar phrases, basically where it says the government has its official laws and the commoners have their private contracts. So they really are viewing private contracts as law between themselves, which is essentially what contract law is viewed as in the West as well. Essentially, contracts are viewed as private ordering of the economic relationship between the parties. Right. So and contracts also clearly complied. The extent contracts follow the legal requirements for certain types of contract. For example, earlier we talked about sales contracts for sale of livestock has to be certified by the government officials. And in this case, the contract would mention that. And in fact, in one example of a contract for sale of slave, there was an official market certificate, which basically talked about granted the seller's petition for permission to sell a 13-year-old female slave. And it pointed out that the slave admitted, and there were 5 guarantors. And so this was clearly an attempt to follow the legal requirements. And they were also using contract to avail themselves of the protections of the Tang laws that, for example, the 3-day right of return. And you see that language in the contract itself as well, where in fact, they would also adopt the language which basically says after 3 days, you can no longer change your mind. So mimicking the code language. They also use contract to minimize or allocate risk. So one of the risks of invalidity of contracts is under Tang law is the requirement of mutual agreement, right? So almost all the contracts that I saw have the basically says that this wasn't a result of a mutual agreement. Essentially, try to anticipate the law's requirement that the contract has to be mutually agreed upon. And then, of course, there's also situations where they were clearly aware of the emperor's tendency to issue broad amnesty. So in the loan agreements, a lot of them basically says that if there is an emperor order granting amnesty, it doesn't apply to this agreement. So they're trying to privately get around the emperor's orders. It's not clear that this was actually legal. I couldn't find any evidence that this was actually either way enforced or denied effect, because it's technically an attempt to get around the emperor's order. But you can see that privately they're trying to say even if there is an amnesty order, we're going to ignore it. Does not apply to this agreement. And also if there's a risk of defects in the title. So apparently theft might be a common problem during the Tang Dynasty. So basically it says if this was stolen, it's the seller's fault, right? Or that if you sell land without asking your family or neighbors first, that's the seller's problem too. The seller has to pay. So they were allocating essentially what happens if there's a defect in the title that's conveyed in the sale. Now, and they were using contract to deter non-performance. Essentially, there's a lot of them contain penalty clauses. Basically, if you don't pay, it's double the amount as penalty. So this is an attempt to deter breach. And certainly the use of collateral. I was just actually really amazed by the use of collateral to a security for a loan, which is basically, you know, Article 9 security of the Uniform Commercial Code, right? That allows creation of security interest in personal property or by contract. Here, the Tang Chinese were doing precisely that. They're saying, if you don't pay, I get to seize your, you know, your furniture, or in some cases, of course, your children. So that's basically reflects the times. But certainly, there's a well-established tradition of using collateral to secure payment of the loan. And the use of guarantors and other intermediaries, and remember, those people would be held criminally liable if one of the parties, if the parties don't perform. So there's a lot of incentive for the guarantors and the intermediaries to make sure that the contract is performed. So those are all the different mechanisms that's designed to make sure that the contract is performed. So based on my very preliminary review, which I admit probably raised more questions than answers, I do think that Tang Dynasty had enacted a sophisticated body of laws governing contractual relationship. And the primary remedy is criminal punishment, although there oftentimes is that the breaching party has to pay anyway, but in addition they get 40 lashes, for example. So, but it is a body of law that governs contractual relationships, and that the contract practices also demonstrate that the Tang laws were effectively incorporated into the daily practices, and that the Tang Chinese were well aware of the legal requirements for contracts. And also the regulations they are entirely consistent with the Tang Code's theme to promote social order and moral rules of trustworthiness. So you can see, because of the criminal punishment and together with the use of the mechanism to ensure performance, probably I would say that contracts were performed a lot more during the Tang Dynasty than these days. I would so. But in any event, so that's all I have. And thank you so much for your time and attention. And I welcome any questions. And my article, which was published in the Tsinghua China Law Review, had a lot of the sites. So if you're curious, would like to know more, please email me. I'm happy to send you the article so that you can check the source yourself. Thank you very much.
Thank you very much, Professor Leonard. This was a very, very rich and fascinating seminar, starting with the general context and then the discussion of the very detailed arrangements of contract law in the Tang Dynasty. We already have a couple of questions. If anybody else wants to ask a question, please use the chat function, send them to me. I will read them out. And if you want your name to be mentioned, please say that as well, because otherwise I will just read out the question without mentioning from whom that question came from. Before I start with the questions from the audience, can I ask one question which interests me, or actually 1.5 questions? You showed that fascinating photo of the Tang Code on display in the Xinjiang Museum. And you mentioned briefly that that was written on paper. And you also said that in Xinjiang, because the air is so dry, that's where you in Turfan, you could find all these things. Are there any sources in other areas, and are they preserved in a different way? That's the first question. And the second question I have is, could you elaborate a little bit about your sources? You showed at one point that collection of Tang Dynasty contract materials. It was a book that you quoted, I guess. But what did you work with? Are there translations? Are there volumes that show hundreds of these contract documents? What were your sources?
Okay, so thank you so much, Dean Wolf, for the questions. So on the first question, are there other sources? Are you talking about other geographic area in the Tang Dynasty?
Yeah.
Yeah, so I think there are. It's just that I didn't have the chance to look at them, which is why I was really disappointed that I was unable to spend my entire 9 months in China.
Oh.
So, in fact, there's continuously excavation of new documents that's becoming available, I think, in the other parts of China, and so I think, if I have more time, I would love to be able to look into that. I think there are more sources. It's just what I've noticed is that probably because of language barrier, a lot of the Chinese archaeologists and historians are doing some great work, but not a lot has been written in English. I think it's probably because of the accessibility to the materials due to language barrier. But I'm pretty sure I was reading even after I finished my research about discoveries in, for example, in some other parts of the country, like Jinzhou. Actually, I grew up in the Jinzhou area in Hubei province. That's where I was stuck during the COVID. But anyway, so I'm positive there are additional areas. Now, the sources that your second question about, what sources did I use? So basically there are multiple versions I mentioned that the Chinese scholars have basically interpreted the annotated Tang code, right? They provided their own interpretation. So the one book that I focused was Professor Qian Daqun. I actually meant to visit him, but again, that didn't come about because of the COVID. And also there's an incredible amount of materials. There's a 10-volume of basically materials that was published by the Chinese Archaeological Society agency, basically documenting the documents that was excavated from the Tuofan region. So there's 10 volume. There's also multiple collections. So I reviewed those as well to try to get a sense. And also very helpfully, there was also a collection of contracts that I think it's a 3-volume contracts, basically setting forth hundreds of contracts, which dates back from earlier in time than the Tang Dynasty, as collected by some Chinese scholars. And I reviewed those as well. So it's basically, and there's also, in addition to the Tang code that's compiled and annotated by Professor Qian, that there's also a Japanese scholar who tried to collect. Essentially, there's not a complete copy of the Tang statues that survived. So, but what Professor Noboru did was to try to recreate the Tang statues at that time by essentially looking at, because in the Song Dynasty, which is the dynasty immediately following after the Tang Dynasty, they adopted a lot of the Tang statues. So, and also the Japanese laws at the time adopted some Tang statues as well. So Professor Naida Noboru essentially was collecting from different sources what he called Tangmin Shiyi. So those are the different sources that I kind of looked at to basically try to get a picture as to what are the laws governing contractual relationships.
Great, fascinating stuff. Let me read out the questions who are coming in. Let me start with the first one. I've learned from that in the Tang Dynasty, the questioner asked, that form and text of contracts were uniformly prescribed by the government. The law of the Great Song Dynasty also clearly stipulates that that whether it is the sale or the transfer of property, a contract must be signed, and the contract must be, can only be considered valid if it is sealed by the government. Therefore, the role of the government in the contract seems to be much more important than that of the parties to the contract. Is this correct? And is this significantly different from the contract laws of other countries in the same period? Could you share your views? And can I ask you, Professor Leonard, to stop sharing your slides, because it makes it easier for me to look at the chat function. Thank you very much. Perfect. Great. Yeah.
All right. Those are great questions. Now, I have to say, remember, I am not trained as a historian. I'm just a trained US lawyer. So with that in mind, I think I did not, when I was reviewing this, I was always curious as to why is it they follow a specific format, right? So basically, it would not, I mean, if you, I would love to know if there's a source that says that it's actually the format is mandated by the government. I did not see any evidence that the format during the Tang Dynasty was mandated by the government, maybe with regard to specific, you know, maybe by mandating you mean that certain, like for example, sales of slaves and livestock have to comply with a particular format and has to be certified by the market supervisor. But with regard to the other contracts, you know, like for example, loan agreements, there's a ton of loan agreements. There's also a ton of agreements for hire, you know, like people were hiring some people to perform military services for them to perform like what I suspect is what they owed to the government, and they were allowed to hire somebody else. So I did not see any evidence that those contracts had to comply with a specific government format. And your other question about other countries, what are the, I would love, this is one of those, if I had my, if I had the choice, I would be devoting the rest of my life trying to figure out, taking across, basically a horizontal look across the world. I wanted to see what other countries are doing around, you know, between 618 and 907, right? The Europeans, you know, for example, I would love to be able to do a comparative study, and I really have not been able to do that. I do know that in the Roman times there was some sort of hypothecation going on as well, essentially. That, you know, but to what extent, at what level, I do not know. And this is one of those things that's on my, I would say, the bucket list, if I could get around to it. And it would be a fascinating area. And with regard to the role of the government in contract law, my general impression is that there's a heavy component of government involvement with regard to certain types of contracts, like, for example, you know, sale of livestock. And so in the United States, you know, contract essentially is a private affair. You know, you sign the contract, and the court's only job is really to interpret a contract. And there's very few government, I'm trying to think about if there's any situation where the government, that there's a required certification by the government. I can't think of an example right now, but on the whole, I would agree that certainly in a dynastic China, there is definitely more paternalistic approach with regard to contracts.
Thank you very much. The comparison with Roman law would, of course, be fascinating. Yeah. Next question. Thank you for a formidable presentation. I've learned a lot from it. I have a question regarding the claim that contracts were viewed as private laws between the parties. Could the clause in the Tang contracts that the government has its laws and the commons have their contracts, that was the, I think the Gongyao Fa, and yeah, on one slide. Yeah, the government has its own laws and the commons have their contracts, not also be understood in a way that contracts are different from laws. So is it, does it mean that the question is that whether the clause that we've just discussed, whether that could be interpreted simply as a statement that you have laws on the one hand, and then you have contracts, and there's a difference?
I mean, that's definitely subject to interpretation, right? I actually I think it's entirely plausible to view it that way, and I'm only making that comment because in the from the U.S. contract law tradition, contract is essentially viewed as sort of a private ordering of affairs. Essentially, they act like private law between the parties, and so certainly, I think it is possible to simply say that they were just acknowledging the existence of a contract. Understand?
Thank you. Next question. What is the difference in penalties or damages of Tang contracts and those in other common law countries, in common law countries like the US, and how does that affect the modern development of contract law?
Okay, well, so if I were to compare this with the modern, contract law, this would be, I do know that under common law, contract law used to be, debtor's prison in a way. So there was also, that's historically, it's possible there's some criminal punishment attached to breach of contracts. So if you don't pay, you get thrown into the prison. That's why they call it debtor's prison. But that was so that the Western contract, so common law contract, stayed away from that tradition. I think after, I would probably say maybe it's 1800s started to evolve away from that. At this time, right, under contract law in the United States, it's especially the damages, typically expectation damages, right? So basically, the aggrieved party, the injured party, is going to be put in the same position as where they would have been had the contract been performed, which typically means money damages. So essentially, in fact, the contract law in the United States these days really disfavor punitive damages. Punitive damages are not awarded. So essentially, the idea, the contract law position right now is in the United States is if we make you whole economically, that's it. That's the only obligation that the breaching party has. So I think it'll be very fascinating to look at historically when the Western common law contract laws, started to basically get rid of the criminal punishment, but focus on compensatory. And there's a lot of economic theories behind this. There's the efficient breach theory, which basically essentially says that we don't want to overly deter people from breaching a contract, which is kind of counterintuitive for people normally to think. Well, the idea is that it's possible sometimes. The efficient breach theory essentially means that there will be situations where it is socially beneficial for parties to be able to walk away from a contract as long as the injured party is compensated for their injury. So that's the efficient breach theory, and it's debatable depending on where you are.
Thank you very much. Getting back to Tang law, next question, and we are getting more and more here at the moment, which shows how interesting your presentation was. Thank you for a very interesting presentation. You mentioned the seller would pay of the sold something they did not own, whether land or personal property. So it's about selling something that you don't own. Would the subject matter have to be returned with the bona fide purchaser to the bona fide purchaser, or would it be returned? Or would it stay with the bona fide purchaser, or would it be returned in that case?
You talking about when the contract basically says if the property was stolen, then it's the seller's fault. Is that the scenario? Yeah, the contract seems to anticipate that if the owner, is trying to reach out to the seller, the buyer basically in that contract says it's the seller's problem. So the seller has to deal with the issue with the owner if the property that was sold to the buyer was stolen. So exactly how that works out in real life, that's basically what the contract says, that essentially if there's a problem with the title, that the cow, for example, the bull was stolen, it's the seller's responsibility to deal with the owner, not the buyers. So yeah, I know that answer is not very satisfactory, but I really there's not enough. One of the big gaping hole is really to see how this contract were actually enforced. I mean, among the documents that I see, I only saw a couple of documents that appears to be written by the magistrate judge. and a couple of complaints about how the parties was refusing to pay, but a couple of sentences, really not a lengthy opinion, that the kind of opinion that I would, hope to see.
Or maybe you can find that when you do further research in other areas. Interesting aspect as well. Next question. How do the powerful officials affect the damages awarded in the past and modern China, and to what extent?
I'm sorry, could you repeat that question again?
Yeah, the question is, how do the powerful officials affect the damages awarded in the past and modern China, and to what extent? So I think it's about implementation. How were damages? How was that implemented?
We're talking about the Tang Dynasty regulation of government
Yes.
transactions with officials,
Yeah.
or with the commoners.
Yes.
I was only I was only able to see the regulations, and I actually don't see any evidence of how that's implemented. That is one of the questions that I cannot answer based on my limited research. I'm sorry.
No worries.
Yeah.
Then we have another question. As marriage contracts are one of the most obvious ways that society promotes morality and maintains social order, have you been or will you be looking at marriage contracts and their regulation by the government as part of your study?
Yeah, I would love to be able to do that. In fact, there are so many different types of contracts that I kind of had to kind of gloss over, just make a mental note. I would love to be able to see that. In fact, one of the things that struck me was the extent of regulations with regard to marital relationships. And also the things like when parents die, what you have to do. So I think all of those are fascinating areas, and I would love to be able to do that. But at this point, though, I don't know when I'm going to be able to get back to China to do the research. Essentially, I feel like one of the things I feel very blessed with is that I grew up in China, so I can read Chinese, although I would have trouble. It would take me a long time to read ancient Chinese, but I can that's why I'm so grateful for the work that the Chinese historians and archaeologists have already done. They really helped me. So I feel very grateful that I'm able to do that, but I'm also frustrated a little bit because I don't have all the time to devote to this, because I'm really, in my heart, I'm a history buff. I just happen to be a lawyer.
Thank you very much. I think we're running out of time. One last quick question before we conclude. You talked about the slaves, and the question is whether slaves were just objects, or were slaves themselves able to enter into contractual relationships with themselves, for example?
No, the slaves did not have capacity to enter into a contract. And slaves were basically treated as livestock.
Okay.
So it's
like Roman law.
Hard for us to, hard us to comprehend, but that was the time.
Good. Thank you very, very much. And again, it was a fantastic talk, fascinating. Thanks to all the questions, to all those who have submitted questions. There's still some pending here, which unfortunately, due to time constraints, we will not be able to raise here. What I will do before concluding the session is announce the upcoming seminars that we have here at CHK Law. Jay, could you please display? Thank you. So we have, and we hope that all of you will join again, the seminar on corporate compliance in the GBA, delivered by Professor Xi Chao, our colleague, on the 8th of November from 12:45 to 1:45. Transboundary Waters, the Rio Silala and the International Court of Justice on the 8th of November, 9th of November, Hong Kong time, 8:30 to 10:45, which would be the 8th of November, 4:30 to 7:45 p.m. MST. Thank you. Then on the 9th of November, the changing nature of the protection of state nationals abroad, history, geopolitics, and human rights by Professor Frederick McGray, 12:30 to 2 o'clock. The Obligations Lab Asia conducts a seminar titled A New Dawn of the Tort Horizon, examining how negligence and nuisance can enable access to compensation for climate-related harms in Australia. That will take place on the 17th of November, 1 to 2 p.m. And the last one is a seminar organized by our Center for Legal Innovation and Digital Society, conducted by our colleague, Dr. Lisa Mick, using ChatGPT prompt engineering for lawyers on the 20th of November, 12:30 to 2 p.m., an online seminar. All these seminars are free, so we hope you can all join. Professor Leonard, thank you very much again for this fascinating seminar. Everybody who has attended will now go back and study Tang Dynasty law much more, and hopefully that will lead to even more exchange about all those issues that you have raised. Thank you very, very much, in particular because we know it's 1 o'clock, it must be 1 o'clock, 2 o'clock in the morning now in the United States. Thank you again, and we hope that you will join us again in the future on a different occasion. Thanks to everybody.
Thank you very much, Dean Wolff, and thank you everybody else for taking the time to be with us today.
Thank you very much. Thanks to everybody for joining, and see you next time. Thank you.